fact is that volunteers, as volunteers, don't have the same protections as paid workers. It always worries me when I say this, especially to room for the volunteer managers, but you can freely go back, discriminate against your volunteers, say to them, don't make you face out. Nothing they can do. Brilliant, isn't it? However, please, at least don't say I told you to do it. However, some volunteers have in the past managed to prove before a tribunal they were employed. They had access to some or all employment rights. This was made more critical as an issue with the introduction of the Minimum Wage Act. Because then, if someone could prove they were a worker, well, they're entitled to the minimum wage. Not only entitled to the minimum wage, but backdated for as long as they've been there. So, important issue. And the problem with this issue has been the amount of grey areas and knowing where you stand. There are some bottom line basics around understanding of the law. The first is that, we do have a clear understanding, theoretically, of how someone can be seen as being employed under various legislation. First step is whether or not someone's working under a contract. Unfortunately, there is some confusion because of our everyday use of language. We tend to think of contracts as being written documents. Unfortunately, that written document is not a contract. Best you can say is it's a description of a contract, because a contract actually is a relationship between the two parties. Where a tribunal or other bodies trying to decide whether or not this relationship is in place, they look for consideration and the intent behind the relationship. Consideration means is something of value being exchanged, or is someone suffering a loss as part of the arrangement. Intent is a bit harder to pin down precisely, because it doesn't necessarily mean that you both sat down and said, we're creating a contract, we're creating a binding agreement between us. In effect, the tribunal would be looking at the relationship as an outside observer and trying to decide whether what was agreed, even if it was expressed as being binding, was intended to be binding. Not necessarily whether or not there was a signed contract or whether the contract was used, but trying to see if that kind of intent to have binding agreements can be inferred from what was actually going on in practice. It gets slightly more complicated, again, by the fact that there are two levels of simplification. There are two forms of employment. People can be employed under the terms within the national minimum wage, the various anti-discrimination legislation, and working time regulations. Often refer to these people as workers. It's a broad definition of employment. Legally, it's called a contract to personally provide services. And basically, if a volunteer is under a contract with their organisation, they're falling into this category. Because a contract would be around the fact that the volunteer is providing work for the organisation, providing their services, therefore have access to the various rights that I mentioned. Could go even further, and they could have full employment rights. This is under a contract of service. Rather than a contract for services, it's of service. And here you'd have entitlement to the rights we normally expect as employees, like the right not to be unfairly dismissed, the right to things like maternity leave, sick pay, and so on. Clear bottom line would be if there's an obligation on the part of the organisation to provide volunteer work, and an obligation for the volunteer to carry out work. So you can see why people get a bit worried about these issues. It can be a bit complicated, especially when people didn't realise that it was an issue. The first major case is in '94, the Relay case. And here a volunteer managed to prove that they're working under a contract. The case in '98, which was volunteer again, managed to prove they worked under a contract. Both of these actually, despite all the panic that they sowed, were really unusual examples of volunteering. However, the next major case that came along in 2000 was much more serious, because here, much closer to what we normally think of as being run-of-the-mill voluntary work. Volunteers found to be working under the contract as family workers under the DDA, Disability Discrimination Act, on the basis that, well, they had their expenses reimbursed, they were trained, they received support in the work that they were doing. They had to provide 6 hours per week of voluntary work, and there were I guess some of the procedures in place felt a bit more employment-like you normally see with volunteers. So I highlighted the fact there that there's actually a procedure for claiming holidays rather than just saying, away in August, you filled out a holiday claim form. But not much different there from most volunteer involving activities. Luckily, the next case that came along again involved Citizens Advice Bureau, as with the previous case. And here, a lot more clarification on where organisations stand with volunteers. The original tribunal, actually, that the case was taken to, found that the volunteers involved were, again, working under a contract. They were workers, referred explicitly back to the previous case, because they had their expenses reimbursed, they were trained, they gained experience, that was felt to be in effect a form of payment. They had a minimum number of hours that they were expected to perform. Luckily, this time it was appealed, and the appeal tribunal said in not so many words, this is ridiculous, this is not employment. And that's that phrase up there, which is a godsend, because this phrase around reasonable expectations, because I think it's a perfect description of the volunteer relationship. It's a great way of describing it. We have expectations of each other. Volunteers expect us to treat them properly, to train them adequately, to look after their health and safety, to ensure that they're covered by equal opportunities policies and so on. And in return, we expect volunteers to turn up, and they're meant to respect our policies and procedures, to give notice if they can't meet any time commitments and so on. And they recognise that this phrase, which was used within the volunteer agreement, did distinguish what was going on from the obligations that we have on the people that we employ. As I said, we don't have reasonable expectations of employees, we have obligations. And other issues which had been of concern, and some lawyers, especially very hard line in some of these areas, such as the fact that there were policies and procedures in place. Some solicitors probably still do actually say, no, you have as little written down as possible. And what this case showed was it wasn't so much what's written down, it was as the content of it. And here, because these policies and procedures were written in this language of expectation, they weren't creating an employment relationship. The other area of concern, especially after that previous decision, was around things such as expenses and training. And here it's quite clearly felt that reimbursement of genuine expenses is not payment, not consideration. Training, well, as the tribunal said, well, of course they go to training. They're not providing these people with some form of perk or benefit by training them to carry out what is quite a specialist role. And obviously experience is just laughed out as an idea of being a form of payment. The problem is, though, that future tribunals still will be making their own decisions based on what's in front of them. But there have been actually, I think I've discovered another case since I wrote this. Cases after the book came out in which the tribunals and the appeal tribunals have explicitly referred back to this Grayson case, used that as guidance and said, no, what we're looking at in front of us is not an employment contract. And these were cases where it's genuine voluntary work, the kind of thing which most people in the room were engaged in. So it shows that this decision is quite strong, quite sound. The fact that if you're reimbursing people's expenses, you're giving them income, you're not making excessive demands on volunteers in terms of obligations, you just have expectations. You can expect volunteers to provide a minimum number of hours per week, but if you're not sanctioning them, if they can't do that, then that's fine. So we've got quite, for as long as I've been involved in volunteering, I think we're on the strongest ground as to where we stand alongside our volunteers.